The government cannot post or cause any discovery to be posted anywhere. Very protective order on the Epstein case. Then Epstein committed suicide in his cell. Come on, DOJ. I think we could get all of the records. It's not even going to be consequential at all because Maureen Comey, the prosecutor, brought the case in that fashion. It was only for Epstein, just to take him out. Only for Maxwell to clean that up. There's nobody else in there.
The information that the government possesses versus the information that the Epstein estate possesses. Those are two separate boxes of information. And the Epstein estate has not been willing to share information with the US government. And so even though we've requested them to do so.
Cops are now swarming the vault where the Epstein records are being housed. Apparently, a lot of internet conversations about these materials and where they're located. So some people on Reddit said, we're going to go stage some protest outside of the facility in Virginia and maybe insurrect the records out of there for the American public. And so this just came out. They said that from Fox News that the FBI has deployed police officers to guard a records facility where these materials are being housed. There's a Bloomberg report saying that the Bureau police that are normally at FBI headquarters were sent out to Virginia. It's a massive facility. The FBI has billions of pages of documents there. 256,000 square foot building. It's like that scene out of Indiana Jones. The additional security followed remarks by Mark Epstein, the disgraced financier's brother, who gave an interview who said that Kash Patel is overseeing a cover-up of the materials. He had no evidence, but he said the files were being edited to remove the names of Republicans. Comments were widely shared online. Reddit users said, we're going to go and protest outside of Winchester. That would be a scene. Bloomberg, citing two people familiar with the internal FBI operation, said the Bureau viewed those discussions as potentially threatening and actually responded by bolstering protection at the facility. Earlier this week, lawmakers passed the Epstein Files Transparency Act, and now the DOJ is submitting additional documentation and motions to unseal more grand jury records in the Ghislaine Maxwell case. We talked about the Epstein filing, and Epstein is apparently dead, but Maxwell is not dead, and her files are still available, and she, of course, since she's alive, can object to the unsealing of the records. And so we've got some new orders that have come down from the judges in this effort, and we'll go through them. But first, here is the DOJ's filing. They sent this one in the Southern District of New York. The last one that we saw was down in Florida, but this one is in the Maxwell case. Epstein's dead, so he can't object to this, but Maxwell is not. She's still alive. And so the DOJ sent this one in, and the judge has issued a response. We'll get to next. Says, all right, Judge, we know that we just asked you to unseal the grand jury transcripts like a couple months ago, but we're back. Pursuant to the Epstein Files Transparency Act and at the direction of Pam Bondi, the DOJ is back. We are respectfully filing this motion to ask you to unseal the grand jury transcripts and the exhibits in conjunction with the law. Now, the DOJ was here before. In fact, we asked you in July, due to extensive public interest, to unseal these records. We sent in a memo. We read all of that here. It was like, can you please, it's like token filings. The court denied the motion, concluding that the federal rules say these don't justify unsealing any of these records. But then something changed. On November 19th, just a week ago, Congress nearly unanimously passed the bill, and Trump signed it into law. There are certain enumerated exceptions, but except from those exceptions, the act requires Pam Bondi, the AG, within 30 days to make publicly available all unclassified records, documents, comms, investigative materials in the DOJ's possession, including the FBI and the U.S. Attorney's offices that relate to 9 topics, including Epstein and Maxwell. Now, the DOJ interprets this act as requiring us to publish the grand jury and the discovery materials in this case, the Ghislaine Maxwell case. Congress said so. So unless one of these permitted bases for withholding this applies, unless there's an exception, we got to release the files. Saying, accordingly, subject to appropriate redactions that are allowed by the act, the DOJ files a renewed motion. We're now asking the court to unseal the records associated with the Maxwell case. We submit the following to you. On July 2nd, 2019, remember this, long time ago, Trump won, a grand jury sitting in the Southern District of New York indicted Epstein. The court entered a protective order. It said the government cannot post or cause any discovery to be posted anywhere. Very protective order on the Epstein case. Then Epstein committed suicide in his cell. Come on, DOJ, come on. Soon after, the court dismissed the indictment and the whole operation was over. How convenient. So no evidence came out at all. Then on June 29th, the grand jury indicted Maxwell. Similarly, numerous offenses, but that's it, no one else. Nobody that Epstein was trafficking these people to got indicted, just Maxwell, who was facilitating the trafficking. Saying here, the court on consent of the parties entered another protective order that said don't talk about Maxwell either. Maureen Comey, James Comey's daughter, prosecuted both of those cases in her mop-up operation. Then in December 21, a jury found Maxwell guilty on several counts. We covered the whole trial here, and it was just highly limited to Maxwell. Nice little bow on it. Epstein's saga is over. Maxwell goes to prison forever. 240 months, and the Second Circuit later affirmed her convictions and her sentence, and the non-prosecution agreement that Epstein got that was applicable to basically everybody didn't apply to Maxwell. Now, the DOJ previously moved this court to unseal the records. The court denied that prior motion. There was no applicable exception under the federal rules of procedure. But then November 19th came around. President Trump signed into law the Epstein Files Transparency Act, and it relates to 9 categories of materials. 1, Epstein files, including all investigations, prosecutions, and custodial matters. Now, also, Ghislaine, they also want flight logs, itineraries, pilot records, vessels, vehicles, and other things. Any immunity or plea deals, any criminal activities or investigatory materials from those proceedings. Entities, corporate, nonprofit, governmental, academic, related to his networks. Any immunity deals for his associates. Internal DOJ comms, emails, memos, meeting notes, charging decisions, and more. All communications memos about anything that was destroyed, any evidence that you cataloged destroyed, any, certificates of destruction, whatever. Documentation of Epstein's detention or death, including incident reports, witness interviews, medical examiner files, autopsy reports, and written records detailing the circumstances and the cause of death, which was a suicide. The dude was indicted for like 2 months. A lot of people get out of cut. James Comey's case just got dismissed in a couple of months. Epstein could have had that too, and he killed himself, one of the most powerful people on the planet. The act allows for certain withholdings and redactions, and so we don't want anything that's going to lead to an invasion of personal privacy or any of those things. And so all of those redactions must be narrowly tailored, and it says in the law, we are required to do these things, okay? They're saying, Judge, we are ordered. Congress ordered us. We don't even really want these things out, but okay, ordered to do it. 15 days and more. If we redact anything, we have to make a summary of the redactions that were made, why they were made. We have to report all this to Congress. So help us. Here, there are multiple features of the act that support an inference that they wanted these records released. And so first, the act expressly references this investigation. Congress is talking about you. They said they want everything from the FBI and the DOJ. That means everything. So that suggests that they're talking about grand jury materials, and we already tried to unseal the grand jury materials and they were denied. So presumably that means that they want those too. Now, the act also affects a categorical disclosure requirement. This makes the act, unlike the statute in the other case, permissible under the law. There's nothing in here in the act that says don't release things, and it shows a clear congressional intent to override some of the grand jury protections. We know that there are secrecy rules for a reason, to protect grand jury proceedings and their integrity, but Congress considered that, they overrode it. In light of the act's clear mandate, this court should authorize the DOJ to release the transcripts and the exhibits and modify any pre-existing protective orders that would prevent public disclosure under your court's orders. The DOJ will work to commit appropriate redactions where necessary, and we have 30 days, so we need an expedited ruling on this, signed by Jay Clayton, the new U.S. attorney in the Southern District of New York, who's taking over this investigation, November 24th, coming in. So once again, this is only for the Ghislaine Maxwell case, right? And the original 2007 investigation into Epstein, I think, is really where the mother lode is, and all of the cover-up in the aftermath of that, all of the non-prosecutions, all of the looking the other ways, every time new evidence crossed some FBI agent's desk, all of that will be very relevant. But in the Maxwell prosecution and in the 2019 Epstein prosecution, I think we could get all of the records. It's not even going to be consequential at all, because Maureen Comey, the prosecutor, brought the case in that fashion. It was only for Epstein, just to take him out, only for Maxwell to clean that up. There's nobody else in there. Even during the trial, it was highly limited, so we didn't see much of anything come down there. Now, the judge got these requests, and in the Epstein case issued that order, and in the Maxwell case issued this order. So in New York, Southern District, the judge responded and said, all right, listen, back in August, the court denied a motion from the Trump DOJ to unseal grand jury transcripts and exhibits. I already denied this. The court found that unsealing was not authorized by the rules of criminal procedure, and there were no special circumstances back then. Now, today, the government filed a new motion to unseal the transcripts and the exhibits again. It says that the Epstein Act authorizes these disclosures, and we can redact victims' info. Now, the government also seeks a corresponding modification of the protective order in this case, and they want an expedited ruling. Now, the court, mindful of the Act's requirement that the AG disclose responsive materials, he's saying, dang, the Congress ordered this. We now set a following schedule for responses. So, Ghislaine Maxwell, over to you. Ghislaine Maxwell will file a letter by December 3rd setting out her position for the government's proposed disclosures. So the question question, of course, is will Maxwell object? Yes. And two, will that carry any weight adverse to Congress? They also want submissions from victims. As with its earlier motion, the government motion is silent as to the rights of the victims, pursuant to the Crime Victims' Rights Act. The court directs the government to provide notice to all victims, and in this case, there were about 4 of them. In the Maxwell case, we heard from 4 women who said that they were, abused or a subject of the crime. The court directs the government to notify the victims, and if the victims want to be heard with respect to any of this stuff, you need to respond by December 3rd as well. Email your stuff to this email address, and the government must do the same as well. Any response by the government by December 10th, and so we'll get a ruling immediately thereafter. So that's in the Ghislaine Maxwell case, and we also had a very similar order come down in the Jeffrey Epstein case. Different judge over here. This one is Richard Berman, and of course this one is over also in the Southern District of New York. This is the new case, not the Florida case. On August 20th, this court denied the DOJ's motion to unseal the grand jury records in this case. Epstein's dead, so we don't need to hear from him. Now, the government filed a second motion, and so we are scheduling the same. Noon by December 3rd, anybody from Epstein's representative on behalf of the deceased defendant Epstein, if he's really dead. Submissions from victims also shall come in. The government shall notify everybody on this one, and then send that in. The government may respond to Epstein and victim submissions by noon on December 8th, and then we'll get a ruling on that one. Also promptly coming down, according to these judges. So some developments over there. We'll see what the judges ultimately do. Kash Patel, of course, was asked about this by Catherine Herridge last night over on Straight to the Point with Catherine Herridge. Encourage you to check her out on all the platforms and give her a subscribe. But here is her interview with Kash.
The Epstein Files Transparency Act has a very tight deadline, 30 days to produce unclassified records. Will the FBI meet the 30-day deadline?
Well, we are working with our partners at the Department of Justice to produce, as we've always committed to producing, what we can lawfully, legally produce. And we will continue to meet those metrics, reminding the public that there are court orders in place, protective orders, and orders to seal in place that legally prohibit the disclosure of information related to any investigation when there's a court order of that fashion. So we're working with DOJ to say if we can produce anything more.
As FBI director, will you commit to as few blacked out sections or redactions as possible?
We always do. We have in our productions to Congress, which have been historic to this year, and we'll treat every matter in the same fashion while also upholding always victims' rights. Victims' rights in any case, whether it's President Trump's case, this case, or any case, the victims' rights statutes are preeminent, and we will protect those victims at all costs.
President Trump told your boss, Attorney General Pam Bondi, to look into the relationship between Jeffrey Epstein and Democrats, including former President Bill Clinton. Is the probe limited to Democrats, or will you follow the facts wherever they lead?
We'll just follow the facts. It's pretty simple for this FBI.
So more charges are possible in the Epstein case?
Based on the new referral, we'll take a look at that and see what evidence comes. But there's an important distinction. The information that government possesses versus the information that the Epstein estate possesses. Those are two separate boxes of information. And the Epstein estate has not been willing to share information with the U.S. government. And so even though we've requested them to do so.
All right, well, they sent a bunch of information over to Congress via subpoena. That's what we were looking at when those emails emerged that Stacey Plaskett was texting with Epstein. So it doesn't sound like he's really interested in prosecuting anybody else. And Kash has been on the record in front of Congress saying that there is no evidence that there were any other third parties. He got asked that point blank. Based on what we have, there's no other evidence. So if they get a bunch of additional evidence, maybe that'll change the equation, but we'll see. The DOJ now asking the courts to unseal the records. Of course, I think that even if those records are unsealed, there's not going to be much in them, except from the Florida case. And we'll, of course, keep our eye on this one. But the saga continues. FBI now swarming around a facility where the records are being housed. DOJ trying to unseal them. Once these judges issue those orders, we'll be here to read those files.